Hi, I'm Jerry Hart. I'm the 8th Ward Commissioner. I'm also the chair of the subcommittee of the board for planning. Welcome everyone tonight. I've been involved with the comprehensive plan since the beginning, so a long process, but we're finally through that, and we've developed a vision. To implement that vision, zoning is kind of the key, one big key aspect. Zoning affects what we build and what we preserve. So as we move forward in trying to be sure that our vision that we've developed can be implemented, we're going to be reviewing our zoning ordinances to see what, if any, need to be changed. I think I can safely say, if you're like me, many of us don't have a full understanding of zoning. So this is our first step. This is some education. Hopefully with tonight's session, and for those of you who can't make it tonight, who watch it later or can come next week, we can all get a basis so that we can work together. We're all have something, we're talking the same language so that we can look at the zoning and make, if we need to make changes, look at what needs to be changed, and we all are up to date on what needs to, on what we're talking about. So again, the first step, thanks for being here, and I'm going to introduce Jamie Angelosian, who's the head of our community development.
Thank you, Commissioner Hart. And thank you, everybody, for coming tonight to our introduction to zoning. It's a super exciting topic. It might not be that exciting to everybody else, but it does affect our daily lives, our quality of life. So in that sense, it is important and it is exciting. So I am the Director of Community Development for Haverford Township. I am the project manager for this Haverford Township Comprehensive Zoning Update. I want to just take this time right now to introduce our presenters for tonight. We are joined by Kristen Camp, a land use attorney with Buckley, Bryan, McGuire, and Morris. They are based out of Westchester. She has over 25 years of experience with municipal zoning and land use law. Kristen's a solicitor for several municipalities in Chester County and has represented municipalities, zoning hearing boards, planning commissions, and private clients in all aspects of municipal zoning and land use. So very qualified, and I have had the privilege of working with Kristen and have learned so much from her in the short time that I worked with her. So I am so pleased to have her here tonight. She will be providing the overview of zoning, reviewing the general concepts, the purpose, and the structure. We are next going to hear from our consultants that the township hired to update the zoning ordinance. So Adam Texa and Kamya Kandwal from IMA Corporation, formerly FHI Studio. They are out of Philadelphia. Adam has been a planner, urban designer for more than a decade, experience with municipalities, counties, nonprofits, private sector clients. He has led numerous comprehensive plans, zoning ordinances, urban design projects, and much more. He has also with him Kamya, who has joined his team recently, a recent grad from UPenn in the city planning program, and they together are our dynamic team that is leading the drafting and the charge on what changes, if any, are going to be made for our zoning ordinance. Tonight, Adam's going to provide to you all an overview of the comprehensive zoning update, including the approach that we're going to take for the update, and then the opportunities for public engagement that are going to come up throughout the process. I do want to take just a minute to mention that the purpose of tonight's meeting is education-based to provide an introduction to zoning, what zoning is, what it is not. We will have time for questions after our presentations, but I ask that the questions do remain focused on general capacity of zoning rather than maybe questions regarding specific parcels or lots in the township. I want everybody to be able to relate to these questions and learn and feel that this educational opportunity has been a benefit to everyone. We will have a hard stop around 8 p.m. so we can be respectful of your time and our consultants' time. And I just want to let everyone know that this session is being recorded. It will be available on haverfordzoning.com within a few days. If you know of people that are not able to make it tonight or next week, please direct them to show and see the viewing on our website. And if you haven't been there, haverfordzoning.com has all of our other outreach opportunities and ways for you to sign up to be updated along the way. All right, so with that, I'll let Kristen start. Thanks.
Thank you, Jamie. So as Jamie said, I've been practicing in zoning and land use. I spend most of my day representing municipalities, zoning hearing boards, planning commissions, and municipal authorities. So I started in 1996. I moved here from Pittsburgh, which reluctantly came to Philadelphia, but now I love it here. This is what I call my home. And my boss at the time said, well, you're primarily going to be working in zoning, and they don't teach you zoning in law school. So I was like, oh, okay, what's zoning all about? And that's all I've done for 30 years. So it is interesting, and there's never a dull moment when you're dealing with zoning. I think that it is the most important ordinance that any municipality has. I think it affects people the most of probably any of the ordinances. And I think that it's a daunting task probably for your governing body to think about amending the ordinance. And I would encourage you, I really thank you for being here, and I encourage you to stay involved in the process because it does impact the residents of the township. So that's my starting point. But anyway, thank you again. We're here to just teach you a little bit about zoning and what it is, what it is, and what it isn't. So it's an ordinance. So the Haverford Township has a code book, right? The code book is the codification of all of the ordinances that have been adopted over time. Zoning is one chapter of that code book. And it was first adopted, not every municipality in the Commonwealth has zoning. Some of the more rural municipalities, some of the smaller boroughs actually don't have zoning. Obviously something as urban and sophisticated as this township would have a zoning ordinance. Most municipalities now within Delaware County, Chester County, obviously Philadelphia has zoning ordinances. But the first one that was adopted here in Haverford was in 1974. That document has what was adopted in 1974 is not exactly what you're going to find in the code book today. And I think if I can send one message to you today, is to realize that a zoning ordinance is a living, breathing document that is susceptible to change, and change isn't bad. There are things in a zoning ordinance today that you had no need to regulate 5 years ago. Example of that, maybe it's longer than 5 years ago, but short-term rentals. Who knew what an Airbnb was, 10 years ago? Now it's a very hot topic that a lot of my municipal clients want to address, and the place to address it primarily is in your zoning code. So I know that some council people think, oh, I should respect what's in zoning, we shouldn't make any changes. I think differently on that. I think as issues arise and problems arise, you have to take a look at your zoning ordinance and see if it's properly regulating, the issue at hand. So it is something that will change over time. As I said, it's one chapter in the Haverford Township Code. It's found in Chapter 182. You can go to your township website, you can get to your code book, and you can go right alphabetically. It's always the last chapter of the book because of Z. It includes, the code has all kind of other topics, right? And it's usually done alphabetically. So you're going to have traffic, parking, property maintenance, building code, all that. But zoning is one of those chapters of the code. So zoning addresses basically how land and buildings and structures can be used. It identifies where various uses of land, buildings, structures, water can be located. It identifies what are called area and bulk regulations. So what that means is you have a specific zoning district. You identify, let's say, in your R1 district, your residential zoning district. You identify within that district what uses are we allowed to have in this land area, in these parcels that are zoned this certain way. primarily in a residential district, you're going to have dwellings. You're going to have single-family dwellings, whether they're detached, attached. You might have multifamily dwellings. You're not going to find uses that are incompatible with residential living in that district. So that district is going to define what uses are allowed and then what they're going to look like on a lot. How big does a lot have to be? Area and bulk requirements are the lot sizes, the setbacks for a structure, how far back does my house have to be from the front yard, from the front lot line? How far back does it have to be from my rear property line? How tall is my building allowed to be? How much of my lot, say I have a 1 acre lot, how much of that lot can be covered with surfaces that don't absorb water, which are defined as impervious surfaces? So your area and bulk requirements, depending upon your zoning district or depending upon the use that you're regulating, they're going to change. And those are things that can also evolve over time. So as stormwater management became a much bigger concern for municipal governments, thanks to the DEP, they took a look at impervious cover limitations. Should we tighten those up? As municipalities or areas become more dense, they may also change those area and bulk requirements. A lot of times changes to zoning are lessons learned from past developments that didn't go the way people thought they were going to go or have negative impacts upon certain things. So for example, heights of buildings. If you've ever been to the borough of Westchester, which is one of my clients, when the new Justice Center came in, the topic was, well, how tall will we allow the county to build this building? And so there was a lot of discussion about changing the height regulations, and that's all contained within zoning. And they allowed them to go to 180 feet. So now when you drive down Market, you see this massive Justice Center, and then new council came in and responded to that and changed the area and bulk to go to a lower height. So those are the kind of things that are contained within zoning. Density is another thing. How many dwellings per acre are you allowed to have? How many apartment buildings per acres are you allowed to have? That's something that's dealt with in zoning. Parking requirements, off-street parking. Every use demands parking. That's something, as trends in the industry change, again, they're sort of related to other matters. We want to limit the amount of impervious cover for stormwater management purposes, but we want to make sure that a specific use has enough parking. So parking regulations over time, at one point it was for every dwelling you need 2 off-street parking spaces. Now you'll hear apartment developers say, well, you don't need 2 parking spaces because people that live in apartments only have 1 car, or they don't have children that have cars. And so that sort of ebbs and flows with industry standards. Loading requirements for some commercial uses. Stores, the retail stores, where are their tractor trailers loading and unloading? Right now, one of the things, again, talking about living, breathing documents, is we didn't know that Amazon was going to be coming and delivering things to everybody's homes, right? So apartment building that was just built in Haverford Township, one of my clients, they don't need a loading space for a tractor trailer. They need places for the Amazon and for the FedEx. So we had to change the ordinance to call out, well, if you have 200 units on a 6-acre lot, how many spaces do you have to allocate so that these Amazon trucks can get in safely and not interfere? So those are the types of things, as our world evolves, we have to address through zoning. Natural resource standards, so steep slopes, hydric soils, floodplains, those types of issues are commonly dealt with in your zoning code and in separate chapters and in separate regulations to make sure that those special features and environmental features are properly protected. Historic resources, that's something that not everybody puts into their zoning. That can be in a standalone chapter. You can have a historic commission that has its own governing regulations that's not contained within zoning. There's some policy reasons why you would put it in zoning, and vice versa. And then specific regulations for various uses. So typically in a code, you'll see, for example, multifamily or apartment buildings, and you'll see a section that deals with what has to happen in a multifamily dwelling. Exactly what are the regulations that apply to that use. So those are primarily things you'll see within zoning. Zoning started in the early 20th century as our areas became more urban, as people started to congregate more closely together. We had to identify where we could put compatible uses together so that you were not negatively impacted as residents from your institutional or your industrial uses that maybe emitted nuisances that would impact the health, safety, and welfare of the residents. So that started in the beginning of the 20th century. The United States Supreme Court, the most famous case, is a case out of Cleveland. My husband actually went to Case Western, so this village of Euclid I'm very familiar with. I spent a lot of time there. But this was where the village of Euclid adopted a zoning ordinance. And a property owner who owned 66 acres and wanted to do what they wanted to do was upset by it and claimed that the ordinance was confiscatory and arbitrary and discriminatory and violated all of their constitutional rights. So the case went all the way to the Supreme Court, and the Supreme Court said no. A municipality has the power, under their police power, to regulate how land can be used and to zone it in various districts and to identify all the things that zoning does. So this is really sort of the seminal case that set the authority to go forward to have municipal governments establish zoning. So when does zoning apply? I know some people think, I've lived in my house for 50 years, I love my house, I don't intend to build anything new on my house. That's probably not going to apply to you then. If you're not planning to change anything to your lot, the existing zoning that you have and how your house was built will continue to govern. So it's really when you want to change something on your own property, or if there's a vacant piece of land and they would like to build something that's not there now, that's where zoning kicks in. It may not just be your principal, your dwelling. It may be if you decide you want to build a retaining wall. Sometimes ordinances don't allow retaining walls in certain areas or only allow them to be a certain height. They might require them to be a certain distance off of your property boundary. So it's not just your dwelling or your house. It might be accessory structures, decks, swimming pools, fences, trellises, carports, those kinds of things. I always say to people, make sure you take a look at your zoning code or call somebody like Jamie to find out whether zoning is going to apply to you. But primarily, if you're going to keep everything status quo, you're not going to be impacted by the changes to the ordinance as far as your property. Could you be impacted by things you see on some other land that might get redeveloped? Yes, you might be impacted by that. As I said, if no changes are proposed, the new zoning ordinance is not going to impact you. They can't take away the rights to what you have currently on your property. And we'll talk about that in a little bit. It's called a non-conforming condition. And that's a constitutionally protected right that once you've built something and it meets the ordinances and the standards at the time that it was built, the fact that they change the law later, they can't go back and retroactively apply that to you. So that's something that's founded in our Constitution. So municipalities, including Haverford, are creatures of statute. And they only can do what the legislature in Pennsylvania says they can do. Being a home rule municipality, it's a little bit different. You actually have broader powers. So I represent primarily second-class townships, first-class townships, and boroughs. And each of those types of municipalities have their own enabling legislation, the second-class township code, the first-class township code, the borough code. As a home rule municipality, you've created your own code. But as far as zoning is concerned, you're still bound by the state statute that gives you the power to impose zoning, and that's called the Municipalities Planning Code. So this is a statute of the General Assembly. It was first adopted in 1968. If you'd like to fall asleep, it's something that you definitely want to pull out and read. And when you read it, because I read it every single day, it never makes sense. It's one of these, it's like it's purposefully written in a not a super easy way to understand. So luckily that keeps me employed, right? But no, that's where all the authority for what is allowed to be in a zoning ordinance, who administers the zoning ordinance, the zoning officer, the zoning hearing board, in some cases the commission, how you go about enforcing a zoning ordinance, the process if somebody's violating it, it's all stated in that code. And that code truly is the Bible of zoning, and you must adhere to it. It's very strictly construed. So when in doubt, I go back and I look to make sure, am I following the MPC? Because that's really what governs. And there's tons and tons of cases that interpret those sections of the municipality's planning code. So lots of judges have had their hands in determining what the ambiguous language means and doesn't mean. Purposes of zoning, we've talked about this a little bit. Again, I go back to the section in the MPC, it's section 604 that says these are what zoning is supposed to be doing. Some of them may not apply to a place like Haverford. Provide for residential housing of various types, accommodate reasonable community growth, provide opportunities to develop a variety, again, of those residential dwelling types and non-residential uses. Promote and protect, you'll hear this language a lot when it comes to zoning. Promote and protect the public health, safety, morals, and general welfare. Well, what does that mean? It's very broad, right? Preserve natural, scenic, and historic values. Again, pretty broad concepts, pretty broad goals. Preserve forests, wetlands, aquifers, floodplains. Prevent overcrowding of land, blight, danger, and congestion in travel and transportation. Again, very broad goals. So you got to take those broad goals and get down into the more granular prohibitions and things you're allowed to do. So again, going back to the MPC, there's certain things that says you shall include these in your zoning, you must include these, and you may include these. So some of these things, again, mandatory provisions. Your zoning ordinance is supposed to be generally consistent with your comprehensive plan. So your township just went through a process of adopting this comprehensive plan that establishes the goals. Those goals now are supposed to be implemented through the more specific regulations that you adopt as part of zoning. There are some uses that over time the legislature must have been lobbied to allow. So there's something called a no-impact home-based business. It's basically somebody working out of their home, a home occupation that doesn't have any impact. Basically, nobody knows that it's around. That's something that the legislature, in an amendment to the municipalities planning code, said, you municipality, you can't stop that. You have to allow that in all districts if they meet these certain standards. Forestry. Timber harvesters have a great lobbying group in Pennsylvania. They were able to amend this law to say that forestry has to be allowed in every zoning district, and it can't unreasonably restrict or regulate that. So that's, again, something not real super important to this area, being as urban as you are, but those are goals that the law says you must do. You must protect prime ag land. You must provide for protection of natural historic features and resources, provide for reasonable development of minerals. So those are pretty specific things that you have to do. You should, in your ordinance, reflect policy goals of the Statement of Community Development Objectives. Those, again, are taken from your comprehensive plan. So if you look specifically today at one of the very first sections of your zoning code, it's 182-102, it's the purpose statement. And that is going to refer you back to the comprehensive plan. These are things that you may permit, regulate, restrict, or determine through your ordinance. Uses of land, water, and the size, the height, the bulk, the location, how you go about maintaining, altering, removing various structures. The areas and dimensions of land and bodies of water, density of population. So the next one, when I mentioned before about in each zoning district, how you allow certain uses, you identify what those uses are. The manner in which uses are permitted, there's 3 different ways. So you can have what's called a by right or a permitted use. That means that as long as you are in that district, you're allowed to have it, the zoning officer can issue a zoning permit for that use. The next kind of use is something called a conditional use. And that's a use that is only available to be approved through a public hearing process by the governing body of the municipality. And there are rules for how that procedure has to be run. There is notice requirements that have to be published in the paper. You have to post the property that's the subject of the application 7 days prior to the hearing. You have to have, in some cases, some municipalities require notice to go out to people within 500 feet. And typically it's uses that could potentially have a more detrimental impact upon neighbors, depending on how the use is operated. So I represented a developer last evening who wants to build a Wawa. They're a preferred developer for a Wawa site out in a more rural area in Chester County. And I showed up at the hearing. It's a conditional use that's allowed in that district. And there were this many people in the room. So this many people got notices of the hearing, and the public was able to become parties to the hearing, cross-examine the witnesses that I was presenting, present their own witnesses, and then appeal the decision that's ultimately rendered. So that process is intended to have the public participate and be able to say to the commissioners, hey, if this Wawa goes here, by the way, I'm going to see the canopy that's 22 feet tall, and I'm going to see the lights that are shining in. And oh, did you know that the stormwater comes onto my property? So it's not something that a zoning officer can just approve with a permit. It's something that the commissioners have made a legislative decision. It's an appropriate use, but we want to take a closer look at it. We want to have this hearing process, and we want neighbors to come, and we want the ability to impose conditions on the use. And that's the most important part about a conditional use, is that it's permitted by public hearing. if approved, but the board can put conditions, and the conditions are meant to protect the public health, safety, welfare. So in the case that I'm working on, for example, a reasonable condition may be that where we abut up against a residential property, we put a denser landscaping buffer. It might be that we have to lower the canopy. It might be that we use a certain kind of lighting. So those are the types of conditions that could come out of that process. The other third way, so you have the by right, you have conditional use, and you have a special exception. Special exception is the same standard as a conditional use, but the governing body that approves it is the zoning hearing board, not the Board of Commissioners. So it's the same law applies. And it used to be more the norm that zoning hearing boards would handle the sort of controversial uses because it sort of took the politics out of it. And it said, okay, you're going to this quasi-judicial zoning hearing board that's appointed members by the council, and they're going to handle it. Same rules that the neighbors can come, be parties, etc. So those are the three ways in a zoning ordinance that you determine how uses are allowed in various districts. The ordinance also, something that probably you don't have here, but in more rural communities, if you have open agricultural land and you'd like to see that preserved, you can transfer the development rights that would occur on that property and put it in an area that's more highly developed. So that's something that the state law allows. And then again, your zoning ordinance is going to tell you who administers it, whose job is it to enforce it, to interpret it, and then to take people, if they're not following it, what are the steps that they have to follow to get enforcement. We talked about this a little bit. You may not unduly restrict display of religious symbols on property being used for religious purposes, and you cannot unreasonably restrict forestry. Those are two prohibitions that are absolutely stated in the municipality's planning code. So again, when you go into chapter 182 of the Haverford Code, you're going to see typically your purpose at the beginning, your community objectives. You're going to have establishment of your zoning districts and your zoning map. So this is your zoning map. It's very hard to read, obviously. I think you could probably go on and go in. And I don't know if, Jamie, do you have an interactive map where you can type in your parcel or your address? Yeah, those are nice. And you can see what zoning district you're in. There's 22 districts. So right now you have quite a few. Again, a lot of residential, sort of going from R1 being the lowest density to the higher density, probably your R9. And then you have office districts, some commercial districts, office, laboratory, light industrial, and then institutional, your outdoor recreation and open space, and your floodplain conservation district. Again, zoning map. Specific to each zoning district, you're going to have your lot sizes, how much street frontage you need, what's the lot width have to be, how much building coverage are we allowed to have. In an R1 district, you're probably limited much more than in a higher density residential district. For example, you might only allow 20% in an R1 district. You might allow up to 80% in your R9 district. Again, those are policy decisions that, as council people, oftentimes you need people like Adam to help you understand, well, show me what that means. Let's take some of the lots within the township and let's identify, okay, if we allow 50%, what does that look like? If we allow 90%, what does that look like? And you have to really see it on a plan to see how it impacts the changes you're making. We talked about setbacks, how far back buildings need to be from property boundaries and street lines, and then heights is also something. You also have supplemental regulations in your zoning ordinance. So we talked about parking. That's a whole article typically. Not only does it tell you how many parking spaces you need per use, it tells you how big the parking space has to be. It tells you what surface it has to be covered with. It tells you what the maximum slope can be. There's a lot of detailed regulations when it comes to parking. Loading, another thing, a lot of detailed regulations about that. Accessory buildings. So in zoning, there's concepts of principal uses and accessory uses or accessory buildings. So on your lot, your accessory uses might be a swimming pool, might be a tennis court, fencing, those kinds of things. So zoning also regulates what is considered accessory, both not only to residential, but to commercial uses. Performance standards, noise regulations are often contained within zoning. So maximum noise decibel levels. Steep slopes, we talked about that. Some of the natural resource protection standards are in zoning. Outdoor dining was something I threw in there because that, again, as COVID came and that became very popular, that became a topic that we had to examine. Do we allow outdoor dining in our commercial districts? And if so, what are the regulations? Are you allowed to be right on the road? Can you be on the sidewalk? How many tables are you allowed to have? I mean, things that came up, and you're never going to get it right the first time, right? You're going to allow it, and you're going to respond. You're going to see that maybe it didn't work, and then you're going to amend it. So one of the topics that we really became popular in the past 5 years. Okay, we talked about non-conforming conditions. So as I mentioned, if your building was built, my house was built in 1996. My house is 50 feet back from my property boundary, 40 feet back from my rear yard, and 20 feet from my 2 neighbors on the side. I have the right to, I'm okay to stay within those boundaries. That is a non-conforming condition. When I built my home, or when the builder built my home, it met the ordinances at the time. The fact that they change the ordinances in the future, I don't have to now change my front yard setback, my rear yard setback. Commercial buildings, the same thing. If you had, say, a hospital use in your institutional district, and a hospital required 1 parking space for every 1,000 square feet or something like that, if the hospital does not, if they make no changes, and that's how many parking spaces they had, the fact that the ordinance changes and increases the number of parking, you can't go back to the hospital and say, guess what, you have to add more parking. That condition is considered a non-conforming condition that they have the lawful right to continue. One of the questions I actually got today, sometimes I think it's easier to understand concepts if I explain real life situations. So the borough of Westchester is the home of Westchester University. Tons of students live in the homes. So when I started in 2000, the borough of Westchester adopted an ordinance in their zoning that defined a use called a student home. It's a maximum of 4 students, unrelated, living in a dwelling unit. And basically they said, look, our neighborhoods down by the university have way too many student homes. The long-term residents are really negatively impacted. So they adopted a student home ordinance that basically made it so that no more student homes could come in. There were separation distance requirements, things like that. So again, 25 years later, new council is saying to me, what can we do about getting rid of these student homes? And I'm like, unfortunately, nothing. When that ordinance was adopted, April 18th of 2001, anybody that had students living in their dwelling unit, landlords that rented to students, have the right to continue to rent to students until such time as they intend to abandon and actually abandon that use. So as much as the current council would love these neighborhoods to turn back to long-term residents and not have student rentals, those landlords have the right to continue to rent them to students. And that's a concept in zoning called non-conforming uses. So in terms of administration, we talked a little about the special exception, that process to get a use approved. The zoning hearing board is a group of 5 people. They're residents of your township. They're appointed by the council. They serve as the judges. And the types of cases that go to them are variances. So if the case of a parking, say for example, a hospital needed 1,000 spaces and they could only put 800. The hospital could file for a variance, something to modify from what the regulations are, and there's a legal standard they have to meet. The zoning hearing board serves as the judge to adjudicate that case. Same thing with special exceptions, and same thing if the zoning officer makes an interpretation of the ordinance and a property owner disagrees with that interpretation, they have the right to go to the zoning hearing board and try to prove that the zoning officer was wrong. So that's the primary function of the zoning hearing board. We talked about the conditional use process, and that's your governing body. Your council has the power to hear those types of cases. Your zoning ordinance will also identify how your ordinance can be amended. So the state law that I mentioned, the MPC, the Municipalities Planning Code, very strict guidelines on exactly how you have to go about amending an ordinance. You cannot just the next meeting, oh, you know what, we want to change this. We don't allow this use anymore. Let's adopt an ordinance tonight. Can't do that. There are processes that have to be followed, public notice requirements, review by the county planning commission, review by your own municipal planning commission. Those kinds of things have to be done, and if they're not done exactly as the law requires, they can be challenged and overturned. And that's a lot of times that happens. So the key players, we talked about the commissioners, the zoning officer, that's the person that's a very hard job. It's a very hard job to take calls from residents, people that want to come into the township with new uses, trying to interpret the ordinance, listening to complaints. So zoning ordinance and zoning enforcement is complaint driven. The municipalities that I represent, the zoning officers don't have time to go out in a car and drive around looking for violations. The violations are reported to them either through a website, an anonymous tip line, or neighbors coming in and saying, hey, my neighbor built this fence and it's over the property boundary. Is there something you can do about that? So that's what the zoning officer typically does. And I think in this case, we'll probably be involved in drafting the new ordinance, I would think, because they have the day-to-day experience of understanding how the current provisions are working or not working. If somebody's violating the ordinance, the zoning officer has to file what's called a notice of violation, and the law says exactly what that notice has to have. You have to give a property owner an appeal right, 30 days, to appeal that to the zoning hearing board. If they don't appeal it to the zoning hearing board, then the municipality can seek civil fines in court, $500 a day for every day of a violation. So those fines can be pretty severe. My experience is municipalities are not trying to penalize their residents. They're trying to get compliance with the code. And so typically you see that it's a back and forth process to try to get compliance. Talked about the zoning hearing board. District court is where any zoning cases go for enforcement and for imposition of fines. And then if you don't like what the district court did or don't like the zoning hearing board's decision, your first appeal right is to take it to the Delaware Court of Common Pleas. Preemption is something that, as I mentioned, zoning is authorized by the legislature. The legislature has also in other statutes taken zoning power away. So one of the cases, or one of the uses that became, I don't know how long ago it was, but medical marijuana dispensaries. That was something that the state said we're going to allow, and these are the laws that the municipality has to follow as far as where you allow these uses. So in certain types of uses, the state says, nope, local municipalities, you're not going to regulate those. I was just asked to deal with this Propane and Liquefied Natural Gas Act. I had a property owner who wanted to put in a propane facility. And there are specific regulations in this law that say what a municipality can and can't regulate with respect to that use. And again, those are probably, that industry lobbied the legislature and said, hey, we're being held up in these municipalities. We're not able to do what we want. So help us by putting these into these various statutes. One of the big, liquor control laws. The liquor code preempts a municipality from saying that, okay, we're going to allow a restaurant, but we're not going to allow a restaurant that has a liquor license. The Liquor Control Board determines who gets a liquor license, not the municipal zoning ordinance. So that's another example of how a state statute takes away power from what can or can't be in the zoning ordinance. Federal fair housing. One of the controversial topics that you often have is group homes. And people not wanting to live near a group home or being concerned about group homes. The Federal Fair Housing Act says you have to treat a group home the way you treat an ordinary single-family dwelling with a family. And so there's a lot of zoning litigation with respect to that type of use in that law. This last one, RLUIPA, again, that's protection for certain religious uses. You can't unreasonably discriminate on how you regulate religious uses. And you have to be reasonable in what types of restrictions you impose upon where they can be located, et cetera. So there's a whole body of case law on that. Some of the important zoning doctrines, when you're interpreting, because it's restrictive legislation, it's strictly construed, but it is construed in favor of the least restrictive use of land. So if you look at a zoning code, and as much as we try to write them to be clear and unambiguous, it never fails that 3 people read the sentence and read it 3 different ways. In that instance, it has to be interpreted in the way that favors the least restrictive use of the land, if that makes sense. So it protects people's property rights, is what I would say. They're presumed to be constitutional, so if you try to challenge an ordinance, it's a pretty tough burden, and it's not an easy case to win. The court will review the ordinance to determine if the specific regulation is reasonably related to a legitimate government interest. And again, we go back to the genesis of zoning, that it's a police power of a municipality to try to protect the public health, safety, and welfare. So the specific provision in the zoning has to be tailored to meet that specific purpose. So in theory, every section of the code is supposed to have a legitimate public purpose for why you're imposing those restrictions. Something that I say this a lot, every use, and we can't even think of every use that there is, but you have to account, every municipality has to account for those uses somewhere. So data centers is this new thing, right? Everybody's worried about data centers and how much energy and water they're using and where will we allow them. And, you know, some of the municipalities I represent, we talk to the planners, we say, data centers aren't coming here, right? There's no highways that they're coming in and off of, but we want to make sure. And so we're going to make sure we put them somewhere. We're going to put them in the industrial district. We want to make sure that somebody doesn't come in and say, you don't regulate data centers. None of your definitions cover what a data center is, and therefore the law says that they can go wherever they want. If they challenge the ordinance and say it's exclusionary, they win. If they win that argument in court, they get to put that use where they want. So it's very important to make sure that sometimes you have catch-alls. Anything that we haven't defined, we're going to put it in this district, and that's a way to protect yourself. And there's nothing unlawful about doing that. So you have to protect. You have to provide for every use. My family lives in Maryland, and they do countywide zoning. And sometimes I think, even though I'd be out of job because I represent municipalities, sometimes I think countywide might make more sense because then you can look at it from a broader scale. There are some municipalities that have done regional zoning, and that's okay too. So that then in a regional zone, if there's 5 or 6 municipalities that get together, the more rural areas can deal with the ag uses, the more urban areas can deal, with the more residential. You don't see that a lot in Pennsylvania. And that's something that's just our historical roots of having each of the municipalities have, the wanting to control that power. But that is something that, maybe at some point will become important. You can't exclude a particular land use. So again, people aren't always happy to have a medical marijuana dispensary or a medical marijuana grower processor. I know when those came in, we had a lot of people coming to the meeting saying, why are you allowing these? Well, the state law required us to allow them, number one. Short-term rentals, that is something that you don't have to allow. The courts, there are cases, it's called slice of life. It was a Pocono case where the court basically said, you don't have to allow transient overnight lodging in a dwelling. That's not a separate use. If you want to regulate it, you should call it out and deal with it so you hit it head on. Something I'm seeing now is limited distilleries. That's another new use that's popped up. So we're trying to figure out, is that a manufacturing use? Is it a restaurant use? What's the best place for that? So again, as new uses evolve, you have to make sure that you're accounting for them somewhere within your municipality. Fair share doctrine, that's really more in the realm of housing, and that I don't think this municipality would ever deal with that because you're so densely populated. But some of the more rural communities that don't account for multifamily, they could claim that they're not providing their fair share of allowing housing. So that's a court-created doctrine. Spot zoning, you might have heard that before. So you have districts, and your zoning districts are supposed to be multiple parcels of property, right? They're not supposed to be one parcel is one district alone. You can't single out a piece of land or a couple pieces of land with different zoning designations than you do the land around it. That's considered spot zoning. So if a developer comes in and they own a 50-acre tract and it's surrounded by all residential uses, and they say, we want to rezone this and make it be institutional, that would probably be spot zoning. You have to zone land consistently with how it's around. No part of a municipality may be left unzoned. We talked about that, and what the ordinance has to apply across the board to all property within your municipality. So that was my part of it. I hope that I didn't completely bore you and confuse you. I'm going to turn it over to Adam, but I will be sticking around if you have any questions, and thank you for your attention.
Thank you so much. I learned a lot. I hope you guys did too. Next steps, I'm just going to talk a little bit about the rezoning process that we've been scoped to do with the township. This is going to be relatively quick. I just wanted to talk a little bit about the fact that your zoning ordinance has got a lot of issues. I think you all sort of identified that as part of the comprehensive planning. You've got some outdated language. You've got a lot of cross-references that go to nowhere. They're like bridges to nowhere, but cross-references to nowhere. There's a lot of inconsistencies. It's long. It's disorganized. The way that I sort of think about it is it's a living document, but it's kind of like a Frankenstein living document. It's kind of limping along on its way. And, most importantly, it's not really, aligned with the community goals of the comprehensive plan. So what we've proposed here is a process that's worked really well for us in the past. So the first phase of what we're going to do is just reformatting and making some initial updates to the ordinance. Okay, so that basically means like taking this like very clunky, maybe a car that doesn't turn over or the wheel kind of thumps as you're going around, and just getting like the tires rotated and inflated, right? That's the idea here. So we're going to reorganize it. Then we'll get into the substantive updates to align it with the comprehensive plan. So the idea is that you've got an ordinance to work in where you're making, really critical decisions. You're having really serious conversations about what you're going to do and what the future of certain districts or uses might be. And you're not at the same time trying to figure out, well, where does this cross-reference go? And why are we talking about this definition that doesn't exist, if that makes sense. Throughout that entire process, there's going to be community engagement, right? We're in that first phase and you all are here and that's part of this process. And then eventually we'll move forward to adoption. I wanted to talk a little bit about some of the things that we're going to be doing in the reformatting and the initial updates. Like I said, we're going to reorganize things a little bit. One of the big things that your ordinance doesn't have a lot of are tables. Tables are really helpful to organize information and to be able to see stuff. And so we're just going to start bringing things into tables, which is going to shorten the ordinance. And then add a limited number of graphics where we feel like, hey, it's pretty obvious what needs to be clarified here. We just need to get a graphic in here so that somebody can understand what that looks like. And then the other big thing is revising and updating definitions where they're real issues. You think you have like 3 different definitions of daycares in your ordinance. It's like, can we just have 1 or maybe 2? The other thing that you've got going on right now is I call this, I don't know who created this. I want to go back in time and shake them. I call it the nesting dolls ordinance. And what it means is when you go into your R3 district, it says, well, all the uses that were permitted in the R2 district are permitted. And then so you go back to the R2 district and it goes, no, all the things in the R2 district are permitted in the R1 district. So you have to go back in, sort of this nested style to figure out what is permitted in your R3. And you've got 9 residential districts. You're going 9, 8, 7, 6, 5, all the way down. We're getting rid of that, right? We're putting in tables that are going to make it a lot easier to read and understand. Like I said, there are 25 missing definitions in your ordinance that we've spotted so far. We're going to bring in those tables. So it's just like an example from another ordinance where, you can see at the top, you've got your different districts, R1, R1A, R2, R3. Along, the side, you've got all of your uses. And then you're just saying, is it permitted? Is it a special exception use? Is it a conditional use? Makes it so much easier to look at a zone and see what's permitted, what's not, and to look at uses and be like, oh, well, what zones are they permitted in or what zones aren't they permitted in? We'll do some illustrations, some simple drawings that are just going to help in interpreting the ordinance. The idea is not to bring in illustrations to change the meaning. It's just to help when there's ever a question of as Kristen mentioned, the idea of well, there are 3 ways to interpret it. Let's draw an illustration so there's only one way to really interpret this. Once we get past that process, then we're going to start doing the substantive updates. That's going to require some more in-depth analysis. We're going to be building a framework for what that looks like, likely going sort of zone by zone, getting into your supplemental regulations, talking about any changes to your zoning map, and then ultimately sort of coming out with draft versions of that. But that's going to be a little bit later in the process. Throughout all of that, we've got a lot of public involvement. So we've got a steering committee that we're going to be meeting with regularly to sort of talk about this. I've met with all the commissioners virtually except for one who I'm still trying to track down. We're going to be doing this education sort of series like we're doing right now. We're going to be having interviews with different stakeholders. So those are maybe like major property owners or developers. And the idea is just to help to understand what issues are coming out in the zoning ordinance. That's not to go to them to say like, what is the answer to our zoning problems? It's to help understand like, oh, whenever we go in for an application for this, we're always having to get a variance. That's a real issue, an obstacle for us. That's good information to us to decide whether or not that should continue to be the case or that's something that needs to get modified. There's a project website, which I hope, just quick raise of hands, how many have visited the website? All right. Please visit. One of the great things you can do on that website is type in your email in that website and you'll get updates throughout the project. So whenever we have public meetings, whenever we're releasing drafts, we'll be pushing it out to all of those emails. It'll also go out through social media and the township's email stuff, but that's like a good way to know that you're going to get updated. Tell your friends, tell your family, talk about it at Thanksgiving, all the fun stuff. We'll be doing some surveys. We've got a limited budget for something called an every door direct mailer, which is the post office. If you get any of that like spam mail, it's basically that. They drop it in every door along the way. But when we're dealing with maybe some special areas that we're going to require like really substantive community engagement, we might use the every door direct mailer to make sure everybody in that district or area is aware of that. We'll be doing some walking tours because I'm a big believer in get out there, point at things, take pictures, talk about it. It's one thing to sort of be in the abstract. It's another thing to look, see, touch, I guess, don't taste, but that kind of stuff. And then, we'll be doing public workshops along the way. So I'm going to stop there and just open it up to questions. I think it would be great for all the speakers to be here. I think there are questions, whether you have for, Kristen about zoning in general or for me about the project specifically. Yeah.
What was the acronym SALDO, S-A-L-D-O, on your slide?
Yeah, it's a great question. So SALDO is the Subdivision and Land Development Ordinance. So there are sort of two ordinances that impact land development, okay? And the way that I think somebody has best explained it to me is zoning sort of talks about like what you can put on your property, what kind of uses you can have, how big the property can be, what are the setbacks. Your SALDO tends to talk a little bit more about like how you can develop your property. So if you were creating new streets, what are the conditions of those streets have to be? How big are your parking spaces? What are the dimensions of those parking spaces? Does that make sense? So there's sort of companion documents. Yeah.
And just a pretty important distinction is zoning applies always in terms of like the applicability is broader. Subdivision and land development only applies to what is defined in the municipality's planning code as subdivision or as land development. So building a house, a single family house on one lot does not constitute subdivision or land development, and therefore that code does not apply at all. So your starting point is what you're doing and what you're proposing to do, does it meet the definition that the state defines, not that you get to change. You must follow the state definition of what is a subdivision and what is a land development. And generally speaking, if you're building 2 or more homes or any commercial use, that constitutes land development. Subdivision obviously is taking a tract of ground and dividing it up into smaller tracts of ground, either for purposes of selling or even leasing. So that's when that code applies. And those are the more specific, as he mentioned, how wide your street is. What's the grade of the street? How long can your block be? A lot of times landscaping and lighting are contained. They can be in zoning, but a lot of times they're in subdivision land development. It depends. And there's pros and cons for having them in both. The commissioners govern subdivision land development. So if you have a vacant tract of ground and somebody wants to come build a commercial building, it goes through the land development process, which is before the commissioners. They have to approve that development plan, and if the plan meets their subdivision land development regulations, then the plan can be approved and built. Beyond zoning and Saldo, there's also stormwater. Those are really the three main land use sort of chapters you have to be aware of.
Start to finish, how long is this process until adoption, would you imagine?
Yeah, so right now we're scoped for like a year and a half, 2 years, but we've talked a lot with Jamie on this, and we recognize that this is going to be a process. We'd like to move through it, sort of steadily, but a part of that is going to depend a little bit on, the community engagement and how that goes, and ultimately, the thing that is important to remember is the commissioners adopt this, so we've got to go through that process as well.
Kristen, are there any groups or organizations that are legally exempt from having to comply with the zoning code?
Not really. For specific uses potentially, but no, not sex of people, do you mean?
Like EPA could come in and decide they want to do
Public utilities, yes. So if I don't know if the Mariner East was anywhere near where you guys are, but the Mariner East was it's now Energy Transfer Partners. They were repurposing a pipeline, and it went through a lot of parts of Chester County, Delaware County. And that was actually, they came into West Goshen and said, well, we need to build a release valve, basically, and it's in a residential neighborhood, and the township was all up in arms, rightfully so, people were concerned, and they pulled well, we're a public utility, we're gonna do what we want, so they got to do what they wanted. So yes, certain.
Yeah, and just to be clear on that, zoning also doesn't affect things like your streets, right? So DOT doesn't have to get permission through, your zoning ordinance for things in the public right away.
Well, yeah, I mean, so preemption, that doctrine that we very briefly talked about, a federal agency could claim that they're preempted from complying with your zoning. So one of the municipalities I represent is Cowan Township, where Thorndale is. I don't know if anyone's ever been there. There's a veterans hospital there. And the zoning officer says, hands off. That's owned by the federal government. We're not going to get involved. We probably could if we really felt like the township could, if they really wanted to try to impose their regulations, but they just feel like let them do what they want. So yeah, the preemption doctrine is, talk about ambiguous and confusing. It's very court driven, case driven, and it's a pretty detailed legal analysis. But yes, that was a very good point.
So I had a question about non-conforming use. Does that end with the sale of a property?
No. Nope, it runs with the land is the terminology. Yes, it carries with the land. It's hard to end it. It's hard to take away that right.
I had a question about the public participation. It seems like it's very heavy on steering committee and surveys and things like that. I find the most valuable thing is to have big audience participation where residents can come in, ask questions, raise concerns, and things like that. I'm just afraid that residents are being excluded from this process.
Yeah, I guess I would not agree with your characterization of the public engagement process. We're going to have a couple of workshops that are very much that process, where we're going to be sitting around and talking about things. The walking tours are going to be open to residents. The surveys are to residents. We've done a lot of this work. There's going to be a lot of opportunity for you to give your input. There's going to be drafts that are going to be publicly released for you to be able to give comments on along the way. There's going to be a lot of opportunity for you all to share your thoughts, share your ideas, and learn with us. This is going to be a process of, every time we embark on a zoning ordinance, I'm learning about your community, right? I'm not from Haverford. This is not my home community. That's one of the benefits or the advantages that I bring. I bring that outside perspective. And then you all are going to be learning through the process with me about the information that I'm bringing and the analysis and the sort of global expertise that I have.
Comments about that. Well, about the really horrible process with the comprehensive plan that we just went through.
And the only thing that I will say to that effect is, I understand that some people were not happy with how the comprehensive planning process worked. One of the reasons why we're putting forward this community engagement plan is to specifically make sure that everybody's involved. This is what FHI Studio does, or I guess we got bought, so I got to say IMEG does now. That is what we do, is we do really heavy community engagement planning work. So you can check us out. We do work in media. We do work in Radnor. We do work in Swarthmore. You know, you can look at our process, and I think our work speaks for itself on that side. Yeah.
Hi, thank you, Adam and Kristen. That was a great presentation. I'm Laura Cavender from the 5th Ward. I will say, in response to my neighbor's question here, that is one of the reasons, as I understand it, we hired your firm, was specifically because you have a strength in community engagement. So I think that's great, and I'm looking forward to that part. My question is about the 2 phases. And I was not aware we had multiple definitions of things in that's extremely confusing. Is that considered a, like sort of a cleanup, or is that a substantive? And then who decides how it's going to be defined? And is that something that we will deliberate as a Board of Commissioners, or is it something the steering committee will do?
Tough questions. There's gonna be some gray area there. Like, I'm not gonna doubt that. You know, we're gonna have to find this delicate balance between what can we just like reorganize and is literally just putting in a different format, and what is going to have the goal is to have a very modest, if no impact. So one example is you've got 3 definitions of daycare. You probably only need 2. We will be presenting to you all and, through working through Jamie about like what those changes are, so that you all can be, we're going to be transparent about that. So you all can sort of evaluate, does this feel like a non-substantive change that is mostly like a cleanup? But it is a little bit like when you go into your basement and you start cleaning things out and you start going like, do I need to keep this? Do I not need to keep this? There are going to be those gray areas. There's some things that are like, the kids are old. We could, and then there's some things where you're like, no, this is going to take time. We're going to need to work on it. But the real goal through this process is just to clean up. And a big one is hopefully give you a bunch of like definitions that you are missing that aren't going to be like radically different, but do address issues of like, hey, we just don't have a definition for this.
And can I just add to what Kristen said earlier? Either way, the process has to go through a certain set process per the MPC, right? The legislature already set forth. So even the reformatting doesn't happen overnight. It will look different, yes, but there is a process in which we have to follow to even do that, right? So no matter what, that process will be followed for each step.
Yeah, and I'll just say, I mean, it doesn't do us any good to not have you all seeing that process unfold. Like, the last thing that I want to be doing here is in a year and a half talking about why we reorganized the ordinance, right? That does me no good, spending hours and hours here at night being like, well, a year and a half ago, if you remember, we moved this. I want you all to be in that process and seeing this unfold so that when we get to the more substantive things, we're not talking about like, well, why is this section here and why is that section here and why did we use a table in this case and not do a list there? Does that make sense? Yeah.
Yep, I just had a question. Just when and where does the ADA fit into the zoning code?
Question. I mean, I know, for example, as far as the building code deals with like parking spots and how large the parking spot has to comply with the ADA. So your zoning ordinance can't supersede, or the ADA is going to govern versus the zoning.
Yeah.
So if there's a more restrictive ADA provision, your zoning can't obviate that. Does that make sense? In terms of, I can't think of how else it would
I mean,
be.
you couldn't presumably create an ordinance that discriminated against people with disabilities. I don't know how you would do that, but you couldn't go out and say, you know, you can't have handicap ramps in your house, for example.
I view the ADA as being more building code driven.
Yeah.
Yeah, for the
It's
most part,
something
that's
that-
going to
and
be
it's-
captured
it's-
in your building code.
And to be honest, I mean, that's such a specific area, and the people that have to enforce that and understand that have certifications and all that, and the Department of Labor and Industry comes and inspects all that. I don't view that so much in zoning as I do as part of your building code,
Yeah.
if that helps.
Agree.
Can you speak a little bit about administrative review and how certain commissions will be empowered and how the zoning code will help to support the mission of those commissions?
Like a historical commission.
Or shade tree commission?
Yeah, I mean, it depends on what authority they provide in the zoning ordinance for those commissions. So for example, if you have historic resources and you have a historic commission in the zoning ordinance, there can be a complete article on what the historic commission's powers are, what types of cases they deal with. For example, maybe it's designation of historic resources, maybe it's permits for demolition of historic resources. So the zoning code for those types of commissions, either shade tree or historic commission, which don't have to be in zoning, those can be standalone chapters and standalone regulations. If they are contained within zoning, the commissioners are going to dictate, and there may be laws on what exactly the historic commission should or shouldn't be doing that they have to comply with. The one thing we didn't talk about, and it is important, the municipalities planning code does have an article on planning commissions. So the planning commission plays an important role in a zoning ordinance. They must review the zoning ordinance and must make a recommendation before it can be adopted by the council. So that is, the planning commission will have a role once the zoning task force is complete and has a final document to present to get to a hearing. The planning commission will have to review that. Sure.
I think we're going there.
Thank you for the presentations. In the phase 2, when we get to the substantial changes, how committed are we to a traditional zoning code versus something like a form-based code? Because people's anxiety over just the general concept of change, we're worried about when new construction happens that it's going to look gross and that it's not going to be within the historic character of this community that's existed for over 100 years or so. So are we going to think about maybe some alternative schemes that prioritize the physical form of what buildings look like and the character, as opposed to just simply focusing on uses and separating those out?
Yeah, it's a great question. So quick show of hands. Who knows what a form-based code is or has heard of that? Oh, no. Relax. It's all right. We're going to get what we get. So so form-based codes are a slightly different way of regulating land. And we can get into what those are and what those look like. Like a little bit of background, FHI Studio, now IMEG, wrote a hybrid form-based code for media boroughs. So if you're interested in what they look like, go look at media boroughs. It's for the residential districts. It sort of gives you a look and feel for what that is. Where we are right now is so far away from the substantive places. We are just trying to get a handle, and I really feel it does quite honestly, feel like wrestling an alligator with your current ordinance. It is all over the place. I want to sort of get it tamed and get it into place. And my personal opinion on all of this is, whether it's performance standards or form-based zoning or design standards, you should choose the tool that's going to give you the best outcome for what you want. You shouldn't go into the project with a sense of like, I'm going to use this tool, right? It's like going to build a closet in your home and you're like, I'm only going to use a hammer. It's like, well, screws are nice too, you know? Like, have you worked with a power drill recently? They're kind of great, you know? So like, yes, I understand that there have been, you know, commitments made in, you know, through the comprehensive planning process. We're going to respect all of that. But I will say, you know, we'll be open to looking at different tools as they are most appropriate. And anything that we do, we will be coming to you all. We will be talking about it. We'll be explaining why we think, you know, doing something is the right choice versus, you know, what you're currently using, if that makes sense. So a really simple example of that is people like to talk about form-based zoning, right? The hidden secret about form-based zoning is it's just regulating vertical development. It's not much different than design standards. It's just a lot more complicated than that. That's why hybrid form-based zoning has come out there. But one thing that a lot of communities have looked at are like dynamic standards, where you set standards based on something like a lot width instead of like a minimum lot size, because lot depths vary so much that you can have a really sort of similar lot that is, quite frankly, like almost twice the size because it's just really deep. And then all of a sudden you can do all this crazy stuff with it and it doesn't make sense. Maybe that's appropriate. Maybe it's not. We'll figure that out as we go through the process. All right?
I feel compelled to say something.
Yeah.
You've criticized the ordinance, and I rightfully so.
Yeah.
I don't want you to think that this township is unique in having a zoning code that's sort of all over the place.
Yeah.
Pretty much every municipality, unless they just went through the zoning process, their ordinance is all over the place because of the comment I made about their living, breathing documents. And when you see a problem, you go and you fix it and you do a quick amendment. And so then that doesn't always, if you didn't have time to do the comprehensive review and see exactly where it fits in, you end up with a document that's been there for 20 years with all these different amendments being, so it's not unusual and it's not a bad thing. I don't want people to think, oh, why didn't our, you know, our staff and our commissioners change this? First of all, it's a very expensive process.
Yeah.
It's very time consuming. There's always a moving target. So it's not unusual that you're in the situation that you're in, and it's actually more the norm than less the norm, so.
Thank you for saying.
Yeah,
I totally
I
agree
know.
with that. There's a reason why we have this process and we've done this, get it into shape, then do the substantive, because we run into so many communities that are like that, not just in Pennsylvania, in Connecticut, New Jersey, New York. It's sort of the commonplace, unfortunately.
So I'm curious, this might be for you, Kristen. So if you're thinking about, for example, non-conforming uses, where maybe you have a neighborhood that has a lot of them, and you can't change those, right? Like they're by right, they will stay. Is there a way to think about how to make the transition smoother between the properties and make them all fit into the neighborhood better? And I would assume that doesn't go into the zoning ordinance, but like how does that kind of thing work? Where could you make recommendations that might improve the consistency in a neighborhood and just make everything feel like
So I think
one?
in terms of if you're changing what was previously there and previously allowed, having what your changes are be not so drastic, I think would be one way to go about it. And I'm not sure I'm capturing
But you're
what you're
not
talking about.
changing what's already there, right? If you have a lot of non.
Well, no, what I'm saying is that the zoning code, the way you're creating a nonconformity is by adopting a new ordinance and changing the regulations that govern when that use came into place. So the change that you're making in the code is what creates the nonconformity. So what I'm saying is evaluating, and I think that's actually one of the goals that we try to look at. We look at what's already there, and we make sure we don't make significantly drastic changes, and now you have all these nonconformities that nobody knows what rules apply, because the law of nonconformities, you want to talk about confusing cases all over the place. So you don't necessarily want to create non-conforming conditions, and you want to look at what's actually built today, and are there any problems with that? Can we live with what's there today in terms of the density, the setbacks, the height, the bulk, whatever? And if you can, don't change it.
So that makes sense to me, but what about non-conforming uses that exist right now?
Yeah.
That you're not going to fix by rewriting the zoning ordinance?
So I think this is, can I just talk about this for a minute? So, this is one of the things that we always get to the edge of things here. And what I like to say is, like, it's easy when we get into this process to feel like zoning can fix all of the problems, right? I mean, I naturally feel that way, right? It's like, oh, that we're doing this tool, right? We're changing these things. It's like, so I think it's important to recognize that there may be nothing that we can do in zoning to address that, and that you do need to look at, the way that I think about it is zoning for the most part is the stick. It's for the most part is the enforcement mechanism that prevents people from doing bad things in your community. It can generally encourage positive things, but for the most part is a preventative measure. You have at your disposal a whole other slew of resources and opportunities to encourage property owners to make things through grants, through engagement, through other planning and sort of, municipal activities that can support those sort of zoning efforts. Does that make sense? And I think the problem that you all, are gonna, maybe it's a good thing, maybe it's a bad thing, but Haverford's a very established community, right? We work in a lot of places. Like I worked in Jersey City. It is moving so fast. You change the zoning ordinance and neighborhoods start like substantively changing because they're right next to New York City. They've had so much less investment over the years. They just move when they make zoning ordinances. You guys, not going to see a ton of change, right? Unless we do something really drastic, which your comp plan isn't calling for. This is going to be slow, gradual change, which maybe you're in the sort of slow, gradual change group and you're like, that's awesome. And maybe you're in a situation where like, it just is going to mean that these changes are going to take a long time to sort of like iteratively roll out. And we're going to see sort of more gradual change to areas to eventually get to the goals and objectives. And if we want to make that go a little faster, we got to go out and find other ways to incentivize and work with those property owners to do something about it. Does that make sense?
Thanks. I just have one last question. You had mentioned in the MPC that it said that you have to permit no impact home-based businesses. What is the definition of no impact? Like I assume like the email, PowerPoint, and Excel jobs.
I was going to say, you asked a lawyer for a definition and she's going to pull out her.
It's defined in the MPC.
See?
In summary, it means I have a home occupation in my house that doesn't have my clients coming to visit me. I don't have deliveries that are over and above.
Kristen, can you, because we're recording.
Sorry.
Yeah.
It's like a home occupation, and there are specific criteria spelled out in the MPC. I don't know them off by heart. I didn't know if maybe they're in your zoning code, but it's basically a home occupation that nobody knows it's really happening at your house because you don't have people coming, you don't have other employees working with you, you're not having delivery and hours of operation that are more like a more impactful home occupation.
Yeah. I tend to think of like
No impact on the
neighborhood.
Yeah, and I think it's limited to 25% of the gross floor area of your dwelling.
Yeah.
The lot size.
The example that I tend to give is like you're a single operator lawyer working out of your home. You don't have clients coming to visit you. No impact home-based business. You're doing welding and building bikes and everybody's coming in day and night to drop off stuff. That has an impact on you.
It's not in here. It's not defined.
Yeah.
Thanks. In the public hearing that we had, there were a lot of things that were changed for Brentford. And I don't have things like offices and things like that. Anything that is done in the comprehensive, in the zoning will be consistent across all the wards and all the areas of the township. Like there wouldn't be a special, Laura can talk about it because she's the commissioner. There was, I think, some areas they just wanted to have zoned as offices as opposed to something else. Can you just comment, is it consistent?
So,
I mean, I can take that one
yeah,
if you'd
please.
like.
Yeah, that would be great.
So for what it's worth, the only changes that were considered for the comprehensive plan in a district was the mixed-use district. None of the other commercial districts, none of the residential districts were anticipating any change. This zoning ordinance update will be consistent with that comprehensive plan. That's how that works, and that's the reason that we would undertake the zoning ordinance update in addition to the cleanup that needs to happen. Okay.
Can I ask a question?
Sure.
All right. Oh, you can't run away. I'm going to ask my questions for you.
Oh, okay.
So you talked about like conditional use process. And I was thinking there, and my question is, why wouldn't we want everything to be permitted as a conditional use? Don't we want, no, hold on. Don't we want public involvement in all land development processes?
Well, it costs a lot of money, number one. Takes a lot of the commissioner's time, number two. There's only so many hours in a day. So no, I think there really should be limited to the more impactful type uses. And the thing, they are considered permitted uses subject to the conditional use approval of the council. So if there are standards that the ordinance calls out, so I'll give the example of the convenience store. Their ordinance tells me exactly what a convenience store is allowed to have and not allowed to have. If I can meet those standards and the way that the one that I'm trying to get approved is going to be operated, does not create a more negative impact than you would ordinarily see from a convenience store, then it must be approved. So as much as they want the public to be involved, I don't want also people to have a false sense of hope that it says, well, because it's conditional use, they can just say no to it. You can't just say no. If it meets the standards and it's being operated in a manner that does not have a more negative impact, it must be approved. But I think more than anything, the municipality cannot charge the cost of conditional uses upon an applicant. So typically you want your consultants to be reviewing those applications. You want, you have to have a court stenographer. It's an expensive process.
Yeah.
It's a time-consuming process. And as I was driving home last night when I had 20 people want to be parties against my applicant, and I know for sure that this township wants this convenience store. They have no retail. It's on a very busy highway that people have been asking for this retail store for quite a long time. I thought to myself, why didn't they make it a permitted use? Because now, potentially, and I'm not trying to take away the public's right. I don't want you to think that's what I'm saying, but it potentially may not, it might be in the courts for a couple of years, because if by chance a neighbor wants to appeal it and says we didn't meet our burden, it may never get built. So it sort of went against the commissioner's goal of really wanting to make that stretch of ground, that highway, have convenience stores. So that would be a negative thing, that it could potentially, it makes the process longer, potentially could stymie the use.
Thank you so
Sure.
much. I appreciate that.
Sure.
That was a very selfish question. I will just say, when we're going through this process, one of the things that I want everybody to kind of be keeping in mind as we're going through this is this interplay between how much effort it's going to take to regulate it is going to increase costs on everybody, right? That's not necessarily a bad thing. There are uses, there are conditions where you all want to spend that time and the money and the energy to get it right. There's a reason why conditional and special exception uses exist. It is also very tempting to be here and be like, well, I'm a little worried if it were 6 inches that way and 5 inches this way, and what if this and what if that, and we should do this. And what that can eventually do is, really impact property owners in your community in the process. And, one of the things that we've heard from some of the conversations we've had already is like, some of your regulations are meaning that like individual property owners right now who want to add like a deck in their backyard are having to hire a lawyer to go through a variance process in order to add that. Like, that's not generally something that most communities want to have happen. And so throughout this entire process, we're going to be just in this back and forth conversation, and you all are going to be having this conversation with each other, which is like, what do we want to permit? How much leeway do we want to permit to encourage the types of things that we want to see? And how much do we want to sort of like, tighten up and be really controlling over what this is? And I always say, don't forget, you're going to have to be the ones at the meetings. And don't forget that, that may mean that somebody may look at a property and say to themselves, I'm walking away. Yeah. Right? There are plenty of properties out there that are owned, that have perfectly great opportunities to become things, but because they're zoned a certain way, the property owner just says, I'm not spending all that money to go through that process. And remember, it's spending all that money to get the approval to do it, right? If that takes a year and a half, I don't know if anybody's paying attention to what's going on in the news. I don't know what's happening in a year and a half. You don't know what's going to happen to your material costs, to your demands, to what it is. So it's just always going to be that back and forth conversation that we're going to be having. All right. So thank you for answering my sucker question. I really appreciate it.
Yeah, thank you.
Thank you all much. Thank you. Can I make one last plug? Sure. So one last plug for people who say, hey, I really want to, spend the time on this. I want people to be involved. It's really helpful for you all to share this information with your friends, your family, your community groups, your church groups, your civic organizations, your T-ball groups. Share the information out, share the website, let people know that it's happening, so at least they can make a decision about whether or not they want to engage, okay? All right, thanks so much.